The judge almost threw her out of the courtroom before she could say a single word. She was standing in the back, near the doors, wearing a gray cardigan that had seen better days and holding a manila folder so thick the edges had started to curl. The bailiff had already taken 2 steps toward her. The opposing counsel, a man named Langford, who billed $800 an hour and knew it, had already turned in his chair to look at her with the particular expression that expensive lawyers reserve for people they consider a waste of everyone's time. She was 51 years old. She had driven 4 hours that morning, and she had found something that 3 attorneys, 2 investigators, and an entire appeals court had missed. Her name was Harriet Boone. Most people, when they first met Harriet, made a decision about her within about 30 seconds. She wore reading glasses on a beaded chain. She clipped coupons. She drove a '09 Civic with a dent in the rear passenger door that she'd been meaning to get fixed for 2 years. She worked the front desk at a veterinary clinic in Macon, Georgia, 3 days a week, and on the other days she took care of her mother, who was 83 and sharp as a tack but couldn't manage the stairs anymore. Nobody looked at Harriet Boone and thought, this woman is going to walk into a Georgia courtroom and dismantle a prosecution's case that has stood for 11 years. But that is exactly what she did. To understand what happened in that courtroom, you have to go back to the beginning. Not the beginning of the trial. The beginning of a Tuesday morning in November, 11 years earlier, when Harriet's younger brother, a man named Curtis Boone, drove to work at a warehouse distribution center outside Savannah and never came home. Curtis was 38 at the time. He was the kind of man people described as steady. He showed up early. He stayed late. He had worked at the same facility for 9 years, and in that time had been written up exactly once, for parking in a spot that turned out to belong to a supervisor. He coached youth basketball on Saturday mornings at the rec center. He sent their mother a card every birthday, a real card with a stamp, not a text. He also, according to the Chatham County District Attorney's Office, had embezzled $340,000 from his employer over the course of 3 years. The case against Curtis looked airtight. There were records, spreadsheets, transfer logs, a paper trail that the prosecution's forensic accountant called meticulous and systematic. There was testimony from a warehouse manager named Garrett Finch who said Curtis had approached him about falsifying receiving logs. There was a bank account in Curtis's name at a credit union in Pooler with $47,000 in it that Curtis said he had no knowledge of. His attorney at the time, a man named Owen Price, who was 64 and tired, told Curtis to take a plea. Curtis refused. He said he hadn't done it. He said he didn't know where that money came from. He said somebody had set him up, and he could not understand why. And he sat at that defense table looking genuinely bewildered in a way that the jury apparently read as arrogance. He was convicted on all counts, sentenced to 14 years. Harriet was in the gallery when the verdict came in. She watched her brother turn to look at her from the defense table, and she would later say that his face in that moment, not crying, not angry, just confused, was the thing that kept her going for the next 11 years. She didn't set out to become an investigator. She would tell you that herself. In the early years after the conviction, she hired and fired 2 different appellate attorneys. The first one ran out of money before he ran out of ideas, and the second one, a woman named Priscilla Hartwell, who was genuinely brilliant, hit a wall on the bank account evidence and eventually had to tell Harriet she didn't see a path forward. Harriet thanked her and sat in her car in the parking deck for 45 minutes before she could make herself drive home. After that, she started doing it herself. She didn't know what she was doing at first. She filed public records requests and got back documents so heavily redacted they looked like crossword puzzles. She ordered the full trial transcript, 12 volumes, and read it at her kitchen table over 6 weeks, highlighting in 3 colors: yellow for things that confused her, pink for things that felt wrong, green for things she wanted to follow up on. By the time she finished, the transcript looked like a garden. She taught herself basic accounting from library books and YouTube videos. She learned how to read forensic audit reports. She called the Georgia Innocence Project and had a long conversation with a staff attorney there who was kind enough to explain what constituted newly discovered evidence and what didn't. She joined an online forum for families of the wrongfully convicted and spent 2 years reading before she posted anything. What she kept coming back to, what she circled in pink again and again, was Garrett Finch, the warehouse manager who had testified against Curtis. The man who said Curtis had asked him to falsify logs. Something about his testimony bothered her. Not any one thing, just a texture, a quality of too neat. In the transcript, Finch's answers were precise in places where memory is usually blurry and blurry in places where detail should be sharp. Harriet couldn't have explained it in legal terms. She just knew, the way you know when a story someone is telling you has been practiced. She started pulling on that thread. It took her 3 years to find what she was looking for. 3 years of FOIA requests and LinkedIn searches and driving to Savannah on her days off to sit in the public library and look at archived local business filings. 3 years of dead ends and redactions, and one attorney who told her, not unkindly, that she was probably seeing patterns because she wanted to see them. What she found, eventually, was a company. A small logistics consulting firm called Meridian Process Solutions, LLC, registered in Delaware, with a registered agent that turned out to be a mail forwarding service. Meridian had been contracted by Curtis's employer during the same period the embezzlement was alleged to have occurred. Their stated purpose was operational efficiency assessment. Their contract was worth $380,000. Meridian Process Solutions LLC had 2 principals. One was a man she'd never heard of, based in Atlanta. The other was Garrett Finch. Harriet sat in a library carrel in Savannah and looked at that filing for a very long time. Then she drove home and called the Georgia Innocence Project back. This time, they listened differently. But here is where it gets complicated. Because a Delaware LLC filing, even one that implicates a key witness, is not automatically grounds for a new hearing. There is a legal standard for newly discovered evidence. It has to be material. It has to not have been discoverable at the time of trial with reasonable diligence. And even then, a judge has to agree it warrants a second look. The Innocence Project connected Harriet with a litigation attorney named Solomon Vance, who was 57 years old, had tried 41 cases, and had the calm, unhurried manner of someone who had learned not to promise things. He reviewed everything Harriet had compiled. He told her the LLC filing was significant, but probably not sufficient on its own. They needed something that connected Finch's financial interest to the fabricated bank account. That was another 18 months of work. What they eventually found, what Harriet found, at 11:30 on a Wednesday night at her kitchen table while her mother was asleep upstairs, was a wire transfer. It was buried in documents she had obtained through a civil subpoena that Solomon had helped her file against the employer's former accounting firm, which had since been dissolved. The documents ran to over 1,000 pages. Harriet had been going through them 15 to 20 pages at a time, evenings and weekends for 4 months. The wire transfer was for $47,200. It originated from an account held by Meridian Process Solutions. It was dated 3 weeks before Curtis was arrested. It went to a credit union in Pooler, Georgia, to an account that Curtis Boone had never opened, to an account that someone had opened for him. Harriet made herself read it twice. Then she called Solomon at an hour that she knew was unreasonable, and when he answered she said, "I found it," and the way she said it, very quiet, very flat, made him sit up in bed and turn the lamp on. The hearing was set for a Thursday in March. Solomon Vance filed the motion for a new trial based on newly discovered evidence. He laid out the Meridian connection, the wire transfer, the timeline. The response from the district attorney's office, which had since turned over twice since Curtis's conviction, was measured. They asked for time to review. They did not oppose the hearing outright. Langford was not the original prosecutor. He had been brought in to defend the conviction on behalf of the DA's office, and he was very good at it. He was the kind of attorney who made everything seem like a minor inconvenience he had already anticipated. He filed a response brief that methodically reframed the wire transfer as ambiguous, challenged the chain of custody on the subpoenaed documents, and suggested that Harriet's amateur investigation was motivated by familial bias and should be viewed accordingly. He used the phrase amateur investigation twice. In writing, Harriet read it in Solomon's office and didn't say anything for a moment. Then she said, "He's going to say that in court, isn't he?" It wasn't really a question. Solomon said, "Probably," she said. "Good." The morning of the hearing, Harriet arrived 45 minutes early. She sat in the second row of the gallery. Curtis was brought in from a facility 3 hours away and was sitting at the defense table in a suit that Harriet had sent him last Christmas, slightly too big in the shoulders. He was 50 now. His hair had gone gray at the temples. When he saw her, he nodded once, and she nodded back. Their mother was not there. She was 83, and the drive was too much, and Harriet had told her she would call as soon as it was over. She had not told her she was worried. There was no point. The hearing began at 9. Solomon presented the evidence methodically. The LLC filing, the wire transfer, a forensic accountant he had retained who testified for 40 minutes about the Meridian funds flow. Langford cross-examined effectively, landing several points about documentation gaps, and Harriet watched the judge, a woman named the Honorable Frances Okafor, early 60s, who had heard approximately everything and showed it, and tried to read her face and could not. Then Langford gave his argument. He was polished. He was organized, and at one point he turned to acknowledge Harriet in the gallery and referred to the grieving sisters' years-long personal crusade, and something about the way he said it. The particular calibration of sympathy and dismissal made 3 people in the gallery shift in their seats. The judge didn't react. She made a note. When Langford was finished, the judge looked at Solomon and said there was one element of the newly discovered evidence she wanted to understand better. She asked him about the wire transfer documentation, specifically the authentication of the subpoenaed records which Langford had challenged. Solomon explained the chain of custody clearly, but the judge pressed. She wanted the original subpoena response correspondence, not the documents themselves. Solomon looked at his files. Then he looked at Harriet, because Harriet had it. She had brought everything. She was the one who had organized the original production, who had logged every document as it came in, who had kept the correspondence in a separate folder precisely because she had read enough about evidentiary procedure to know that the correspondence mattered. She handed the folder to the bailiff, who passed it to Solomon, who passed it to the judge. The judge read for approximately 4 minutes. The courtroom was quiet in the specific way that courtrooms get quiet when something is shifting. Then Judge Okafor looked up and said, "I'd like to ask the record to reflect that the authentication is sufficient." She paused. "Mr. Langford, your challenge to the documentation is overruled." Langford's expression did not change. He was too practiced for that. But then Judge Okafor said something that Harriet had not expected. She said, "I also want to note for the record that the volume and organization of the documentary evidence compiled by Ms. Boone is," she paused, looked at her notes, "frankly extraordinary for any investigation, amateur or otherwise." She did not look at Langford when she said it. The ruling came 12 days later. Judge Okafor granted the motion for a new trial on the grounds of newly discovered evidence material to the defense. She found that the Meridian connection and the wire transfer, taken together, were sufficient to undermine confidence in the original verdict. She also found, and this part made Solomon call Harriet at 7 in the morning, something he had never done before, that there was credible evidence of third-party culpability that had not been presented to the original jury. The DA's office declined to retry the case. Curtis Boone was released on a Thursday afternoon. Harriet drove the 4 hours to pick him up. She had told herself she was not going to cry in front of him, and she managed it until they were in the parking lot. And then she didn't manage it, and neither did he, and they stood next to her dented Civic for a while without saying anything. He was 50 years old. He had lost 11 years. He would spend the next several months trying to reconnect with a daughter who was now 22 and had been 11 when he went away, trying to find work, trying to figure out who he was in a world that had moved on without him. None of that was simple. None of it was the end of anything, really. But he was out. Garrett Finch was indicted 8 months later on charges of fraud and perjury. The civil suit against the employer for negligent retention of records that had enabled the original prosecution was settled out of court for a figure that Harriet's attorney told her she was not permitted to disclose, but which covered her mother's care for the foreseeable future, and then some. Harriet went back to work at the vet clinic. She still drives the '09 Civic. She has not yet gotten the dent fixed. I've thought about Harriet Boone a lot since I first heard this story, about what it means that she did, essentially alone, what trained investigators and appellate attorneys could not, about what she saw in that transcript that they missed, or chose not to pursue, or simply didn't have the time or love or stubbornness to follow. I think about Langford calling it an amateur investigation, twice, and what he must have felt when the judge said what she said. I think about Curtis sitting in that courtroom for the first time in 11 years, watching his sister hand a folder to a bailiff that would change everything, and I keep coming back to one question. Not a legal question, a human one. If someone you loved was convicted of something you knew they didn't do, and everyone told you there was nothing more to be done, what would you do? Because Harriet Boone spent 11 years answering that question in a kitchen in Macon, Georgia, at a table covered in highlighted transcripts and library books and FOIA requests, with her reading glasses on their beaded chain and her mother asleep upstairs. She decided that nothing more could be done was not the same as nothing more would be done, and she turned out to be right.